rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is the time set for oral argument in our case number CV140355, Enterprising Solutions, Inc. et al. Versus Stacy Ellis et al. Each side is allocated 20 minutes for oral argument. Appellant, if you wish to reserve a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium. Out of respect for counsel, I would ask those in attendance to make sure that any cell phones are disabled so counsel's presentation is not interrupted. We have reviewed the briefs. We've conferenced the case this morning. We encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted to YouTube in due course. Accordingly, as you begin your argument, we would ask that you state your name and the party that you represent. With that, let's start with Mr. Flynn.
Thank you. If I may reserve 5 minutes for rebuttal.
Very well.
May it please the court, my name is John Flynn with the law firm of Diagardi Flynn, and along with my co-counsel and partner Peter Molinar, we represent Appellant Enterprising Solutions Incorporated. The issue before this court is clear. The issue is, does a claim arise and the statute of limitations begin to run against an insurance agent when an insurance company has reserved its rights and is paying claims, in this case, to the tune of $430,000. The appellee would have you believe that the claim did arise and that the statute of limitations was running. As is indicated in the commercial union case, however, which we do believe is controlling in this matter, the statute of limitations did not run. There was not appreciable harm. There was not irremediable harm.
Was National Union paying the claims, and if so, pursuant to a reservation of right, and if so, what was the basis of the $900,000+ in damages that were alleged in the complaint in the coverage case?
Potential claims dollars arising under the SunWest plan.
So that wasn't money that ESL had paid out of pocket to that date?
Correct.
Because National Union was covering them under a reservation?
Yes, ma'am. To the tune of $430,000. Claims were continually coming in based on the underfunded plan.
So the only, if you want to call them damages, out-of-pocket costs that ESL had incurred to date would be the costs and attorney's fees in litigating the coverage case.
Yes, ma'am.
You help me understand how you got to the $970,000. What's the basis for that allegation?
The amount of claims that were coming through the underfunded plan, claims, approximately 550 demands were kind of pouring in the door. SunWest was working with National Union NUFIC in trying to administer and resolve those claims.
So those were claims as of the date of the filing of the federal action?
I didn't handle, but that's my understanding from the record, Your Honor.
Well, and then the payment of the claims of $430,000, which is a number, it's a little higher than that, but that is of record, was a number as of almost 2 years later, right? So doesn't that suggest there were $500,000 worth of claims that weren't paid for at the time the federal action was filed?
Yes, there were still claims in process, there were still claims unpaid. It was still a moving target. It was not set. SunWest did not know where it would end up. At that point, it had been multiple years continuing to plow through and deal with this, avalanche of claims with an insurance company that by that time had issued 7 reservation of rights letters. None of them, obviously, reservation of rights, not declining coverage, listing out. I'm sorry.
But the point of my question is that seems to be a gap of about $500,000 of claims that were made but were not paid for by National Union. Am I misunderstanding the record?
No, sir.
Were
Okay.
they paid for by ESL, though?
No.
So
They were still floating. They were still floating. They were still.
So they'd been
floating out.
incurred by the time the federal litigation, or what became the federal litigation, was filed.
They were being asserted. There were claims that were continuing to pour in.
But that was the number as of that date.
That's my understanding.
Okay.
The from the date of tender of the claims, SunWest understood that it had procured insurance coverage to cover its complete operations. Obviously, it isn't a crystal clear matter, although Appellee would like you to peek back now and know that it was based upon the ultimate decision of the district court. But in fact, it wasn't. If it was crystal clear, we wouldn't have had 7 reservation of rights letters. We wouldn't have had 2 rounds of intense cross motions for summary judgment before the district court. The first round, heavily litigated, and the district court was unable to render a decision at that time. If a decision and a decision from the district court, although we may not agree with it, the decision ultimately confirmed no coverage existed, which triggered this lawsuit against the agent for the negligent procurement of the policy. But that decision could have gone a bunch of different directions. There were 13 grounds asserted as possible exclusions in the reservation of rights. They could have determined that the tender was late, or that some specific action with respect to some particular claim submission or operation of the plan squeezed it in within some certain exclusion. It ended up being a complete victory for National Union, but that was not a fait accompli. And in fact, it took 2 rounds of motions for summary judgment over a couple of years to get to that point. But it's at that point when ESI, the appellant, knew that it had been harmed as it relates to its claims against the agent.
Well, let me go back to your comment that you think that commercial union is controlling. Does it matter if I understand the facts in commercial union? I want to look to see when I'm going to call them the malpractice plaintiff. You're the malpractice plaintiff, in essence. Commercial union was the malpractice plaintiff. Commercial union didn't actually suffer damage. I mean, there wasn't a judgment against it. There weren't claims that they knew they were going to have to pay, or someone was going to have to pay, until, if I understand this right, until the court ultimately said in commercial union, you can't get around that federal insurance case. And at that point, so therefore that's when they're allegedly, quote, damaged. Now in your case, you have these claims coming in, and presumably you knew they were going to have to be paid.
And they were being paid.
And they were being paid, but the question is who's going to pay them? Because for God knows, for any reason, if National Union doesn't have to pay them, and for some reason SunWest doesn't have to pay them, you're going to have to pay them to the extent you can, right? These are claims out there under the plan that presumably are valid. Does that distinguish commercial union? Because in essence, commercial union isn't really doesn't know it's got an exposure to valid claims until after the court says, no, the insurance company isn't, it can't get out of coverage.
Well, it knew it had an exposure. It knew for an extended period of time that it had an exposure.
Right.
The ultimate decision by the trustee to pursue the claims in the bankruptcy, and then ultimately in that adversary action, the decision of the district court confirmed that the controlling law was missed by the lawyer. In this case, and at that point, they had irremedial damage. The doors dropped.
At the time the judge rules.
Yes. In this case, we're in exactly the same position. Claims are the deck action was filed as deck actions typically are because of the uncertainty, because you're sitting out there, twisting in the wind, hear claims pouring in, and it's going on for an extended period of time. But claims are being paid. There is no irremediable damage there. $430,000 in damages, in claims, are being paid. And then it was only when the district court on the second round of motions for summary judgment ruled as it did, grabbing onto that one exclusion, that the damages were fixed, that the coverage didn't apply.
And I guess it depends on how you want to define damages.
I'm sorry?
It depends partially how you want to define damage, how you perceive damages.
Yes, sir.
Because you could say, well, they were damaged in the sense that we knew we had to pay these claims. We're just looking for a defendant to pay it. As
And
opposed to commercial union, if they found no coverage, they were home free.
And if the district court found coverage here, we're home free.
Why
respectfully submit it's the same.
Why doesn't the answer constitute damage? Once they tell you, we don't think we have coverage.
Well,
Isn't that enough?
no, sir. It is, I respectfully submit it's not. They had, that is, if you ruled that was enough, you are going to gut the impact and effect of a reservation of rights, because and you're going to change the entire dynamic of a deck action, which is intended to have a court determine a issue of uncertainty relative to coverage. They have not confirmed coverage, and thus they're going to assert a denial in their answer. Wish they had confirmed coverage, we wouldn't be here. But that act in and of itself doesn't tell us that the insurance agent has been negligent in procuring the coverage that the insurance agent thought they had procured.
Right, but that's a slightly different question. I mean, does it put you on notice that they may prevail, National Union may prevail, because they're coming in and saying there is no coverage? At least it puts you on notice to say, I better do something as to the agent, because the agent, if ultimately they find that I don't have coverage, I've got a question that I may be able to sue the agent for not getting me the proper policy. And so at least boy, everything's at issue. It's just a question of how the court's going to rule.
Everything's at issue. Everything's up in the air. Everything is, as it relates to the harm or damage, it is speculative. It is remedial at that time.
But isn't it?
And I'm sorry, I didn't mean to.
No, go ahead. I interrupted you. Go ahead.
You're right.
As it relates to the holdings in the commercial, one of the holdings or part of the commercial union case.
The court spoke of the fact that that the ultimate decision of the underlying court could resolve the entire matter. And why would we be pushing other litigants into court when there's harm that's remedial in nature, it's speculative, and this all may have been for naught.
But
and
remember,
not required.
to follow up on that, commercial union, the date of accrual was set on the denial of a motion for summary judgment, right? I mean, it wasn't, here we're a lot further down the road. It was the grant of summary judgment in what became the federal case, right, that you're saying caused the limitations period to accrue.
It was yes, sir. And in this case, we were still, just as if there were arguments to be had about distinguishing the underlying controlling case, but in the commercial union case, just like there were arguments to be had here, but until the decision was rendered, nobody had an answer.
Can I ask, one way of looking at, there are really kind of two inquiries for when a limitation period accrues. One is, when the plaintiff knows or in the exercise of reasonable diligence should have known of the defendant's negligence conduct, the knowledge component. And then the other is has suffered actual injury or damage. When did ESI, for purposes of accrual, incur damage? When was it damaged?
As it relates to its claims against the insurance agent, when the court ruled against it on the second round of motions for summary judgment, because up until that point in time, you had an open, extensively papered reservation of rights file. You had an agent saying, yeah, I procured the coverage that for your entire business operations as you requested, and you had all of these claims being paid. It was at that point in time when there was irremediable damage. The district court ruled. Is
your position that that's the same date when your client had knowledge, not earlier in the process?
Yes.
Okay.
Yes, sir.
Judge Johnson.
I was just going to say, CDT says that the principles of commercial union apply to negligence claims against professionals generally. why is it that an insurance agent is a professional within that category?
Well, an insurance agent is trained, licensed by the state, acts in a, depending upon the case law you read, in a fiduciary or quasi-fiduciary capacity, assisting its clients in procuring insurance coverage. The bigger issue, though, as it relates to CDT and really the underpinnings of all these cases is why do we have a statute of limitations? We don't want people sleeping on their rights. We don't want stale claims being brought before the court. And that's not what we have here. We had sophisticated business people. We had extremely competent lawyers who couldn't provide an insurance company with any definitive opinion about coverage. If they did, we would not have 7 reservation rights letters. We have an incredibly experienced district court judge who was hiking his way down from Alaska, as I remember, to handle the underlying coverage case, who couldn't render a decision. Everybody was working it. There are no stale claims. Claims are being paid. ESI has no idea as to where that's going to end up falling out with the insurance company, but its agent says it procured the coverage, and ESI believes it has the coverage.
It knows one of 2 people is responsible, assuming that it's not ESI setting rates improperly. So let's set that aside for a minute. It knows either it's National Union or it's SunWest, right?
Yes.
Isn't,
Or
and it
or
shows.
nobody.
I've been calling SunWest the, and SunWest isn't the, SunWest is ESI.
It's a DBA, but ESI is the.
I apologize. Right.
I do the same thing. I'm sorry. Go
it's
ahead.
L.
Sir.
No, that was really the question.
I'm sorry. I lost the question there. I'm sorry.
You answered it. I appreciate
I
it.
know
Let me-
I'm over time as far as rebuttal, but yes,
Let
sir.
me just raise one other point.
Yes, sir.
Let's assume, I'm having a problem conceptualizing why this isn't simply a matter of serially trying to find a defendant to cover your losses. Imagine, let me give you the hypothetical and tell me what's wrong with it. You go to a hospital and something goes wrong and you're damaged. You want to sue somebody, so you say the hospital. Hospital was negligent, not the surgeon. Don't sue the surgeon. And you get to summary judgment or judgment, and the court says, and there's no non-parties at fault. And the court says, the hospital wasn't negligent. You then say, I want to sue the surgeon. For whatever reason, you didn't sue him the first time around. Nobody brought him in as a non-party at fault. Isn't that a stale claim against the surgeon?
It could be if it's rising under that same exact set of facts. Here, maybe the better analogy would be that you proceed with your first action, but you're unaware based upon you couldn't have found it through due diligence or because of concealment or something, a claim that arose.
Right.
Here you don't have, you have a reasonable belief supported by reservation of rights, the agent's testimony and opinion, and your lawyer's opinion and your own understanding that you have coverage. You're not going to go off half-cocked suing somebody when you believe you have that coverage and you don't have anything definitive from a court or from the insurance company telling you you don't. Your Honor, I know I've gone over here. I'll sit down now and wait for rebuttal.
Very well, and we're going to hear from Apley in just a moment. Madam Bailiff, we're going to give each side 2 additional minutes, so if you could add that time before we get started.
While we're waiting, would one of the clerks close the interior doors, please? Thanks.
Thank you. Mr. McCarthy.
Thank you. May it please the court, I'm Dan McCarthy, and with me at council table is Mike Raymond. We represent SunWest Insurance and Stacy and Hal Ellis. Quite simply, ESI's claim here is barred by the statute of limitations because it was asserted almost 3 years after it accrued. By the time that ESI sued National Union, it had the uncovered losses. The claims were pouring in. That's undisputed. It knew that it was going to have to pay the claims. These are first-party health insurance types claims, so liability is not really a dispute. ESI had been told repeatedly by National Union, there's no fiduciary liability coverage. And that really goes to the nature of the district court dispute, if you will. They fought about whether these are fiduciary liability claims, but there wasn't a big fight about whether there's fiduciary liability coverage. That's plain. There's no fiduciary liability coverage in the policies, and ESI had been told that repeatedly.
But there must have been it must have been more difficult than that if it took 2 years for,
Oh, well, indeed.
Right.
I don't mean to suggest that it was a simple issue at all. I mean, they certainly fought about whether these claims were administrative type claims that would be.
National Union would be obligated to pay them,
Yes.
which
yes.
is, okay.
Which
But in
is,
the meantime, National Union continued to pay them.
National Union did pay some claims. National Union continued to defend under reservation of rights. But the reservations were clear. There's no fiduciary liability coverage.
But Counsel, you're not arguing the reservation of rights caused the accrual limitations period, fair?
No. We think that certainly by the time that ESI sues National Union, when National Union files its answer and again says, look, you don't have fiduciary liability coverage, and this is coverage that ESI now contends it asked its agent to get, that its agent said it got. This is coverage that it said it paid for.
So is your tolling date, is your accrual date the filing of National Union's answer?
We think that would be probably the latest date. The most generous date you could pick would be the date.
And how was that different than National Union's reservation of rights letters from a significance perspective?
Well, I'm not sure that substantively it is all that different. I mean, the answer, as I recall from the record, much like the reservation of rights letters, simply says, look, you don't have this coverage. If you thought you had it, you're now on notice that you don't. And at that point,
We're now on notice that National Union thought they didn't.
well, I mean, true enough, but as again, this goes to the nature of the dispute. I don't understand even ESI to be claiming, oh, that coverage is actually in the policies, except maybe in a tangential reasonable expectations sort of way.
And I don't, no matter what, see that in front of us. So I'm just so counsel are clear. But let me ask you, the answer is fairly definitive, but again, reservation of rights, payment of claims, that's a somewhat different message. Would you agree than simply saying there's no coverage here, we're not paying anything? Then it's pretty clear.
Yes, that's true. That's true. A reservation of rights is not a definitive coverage denial, but the label doesn't control. I guess maybe I wasn't clear in the point I'm trying to make, is it's the content of the letter that matters. There can be a reservation of rights based on uncertainty about the coverage, but here the reservation was more directed at the type of claims. They weren't sure whether the claims fell under the fiduciary liability exclusions. But it was pretty clear, and the district court found this in its order, the policies plainly say there's no fiduciary liability coverage. And that's what was needed. So because of that, ESI, I'm sorry.
I'd like to interrupt you. How is, from ESI's perspective, though, the issue is National Union going to pay the claims? So that's at least how I view this issue. So how does it matter what the reason National Union is asserting it's not going to pay the claims? Does it matter that National Union is saying, I'm not going to pay them because they're not really fiduciary, they're not really that kind of claim, or there's no coverage for whatever claim they're making? Does that matter from the purposes of this dispute?
Well, it matters because that's the coverage that ESI now contends its agents didn't secure. I mean, this lawsuit has to be about the coverage that they needed and don't have, and that's it. The district court identified it. It's fiduciary liability coverage. That's what they thought they bought. That's what they said they bought. That's what they claim their agent told them they had. And now, according to the policy and the district court, it's not there. And they knew that back in May of 2010. I mean, that alone is probably enough damage to trigger the accrual date.
And that was when? May of 2010?
Well, that would have come certainly by the time of the answer. was, again, another, it was probably included in all of the reservation of rights. In fact, I think in the trial court, we covered it in some detail with the trial court judge. Even the very first letter said you don't have that coverage. But on top of that, they have the attorney's fees. They're now embroiled in a lawsuit with National Union. They're incurring fees and costs.
But isn't there a case law saying you can only look at that sort of in the rearview mirror? You can't merely incurring fees in litigation doesn't cause limitations to accrue. I mean, I understand that to explain to a client, for example, that yes, we're going to have to pay fees for months that may far exceed anything you would imagine, but that's still not damages for a limitations period. But isn't that kind of what the case law says?
Well, there is one case that I'm aware of, and I think it's Myers versus Woods, if I recall, and it talks about a very small expenditure of attorney's fees that preceded by some period of time the vast majority of the loss that was sustained. And in that context, the court said, you know, for considering judicial efficiency, we're not sure it makes sense to apply the statute of limitations or the accrual date based on the expenditure of those fees in this instance. Now, there's another, I think it's maybe a Ninth Circuit case or a district court case where the judge reaches the opposite conclusion and says under Arizona law, once you get embroiled in a dispute where you are trying to establish coverage, you do have damages for purposes of the statute of limitation. That may be the Manzanita Park case.
In the toy case, the malpractice plaintiff asserted or had incurred attorney's fees and asserted fees, and that didn't prevent the court from holding there that the claim had not accrued. That's
true. But the toy case is much like commercial union in that until the client actually gets an adverse ruling, there's a chance that there's no damage at all. Because if the court had construed that contract the way the clients wanted the court to construe it, then they would have been okay.
But isn't that the same thing here? If Judge Martone had ruled differently in the coverage case here, would ESI have suffered any damage?
Yes. What they were trying to do is recover the damages they had sustained. Remember, these are indemnity. It's indemnity is what they're after. So they want to get payment for these claims. They want to recover their attorney's fees, I'm sure. But all of that is recovering damage you've already sustained. And we think that's a significant difference between a situation where you don't sustain any damage or here, the claims are made,
what
the
other
fees
than
are
the
paid.
attorney's fees in litigating the coverage case had ESI come out of pocket for?
Out of pocket, I don't know that they'd come out of pocket to pay any of the claims. They had the attorney's fees. They didn't get the coverage they paid for, so they were out of pocket whatever that cost was.
Although if the coverage case had come out differently, then they would have.
Well, I don't think they would have had fiduciary liability coverage because that's not in the policy. They might have been able to convince the judge that these aren't fiduciary liability claims, but it wouldn't have necessarily created the coverage that they now claim they purchased.
How is it different to say if the coverage case had come out differently? By that I mean to say if National Union had been ordered to pay the claims.
Right.
What damage would ESI have incurred in that event?
Well, they would have possibly recovered their attorney's fees. They possibly would have had, National Union would have had to pay all these indemnity claims that were being made. There is reference in one exhibit, I think it's Exhibit 6, to SunWest Insurance's statement of facts, where in a letter authored by ESI's counsel to National Union's counsel, they make reference to some lost business or lost business income there. So they were out that damage as well. That is really the only reference that I could find in the record to it, so it's not particularly well developed, but that's there as well. And these are problems that are all associated with the deficiencies in the policy, and those deficiencies, as ESI would have us believe today, are directly related to its insurance agents.
Do you think that the CDT comment about whatever rule was established by commercial union applies to claims against professionals, do you think that would include a claim against an insurance agent or not?
To a point. I think that generally the same rules apply, but there are differences. And one of them is discussed in cases where the attorney or the legal malpractice arises in the context of litigation.
Right, but
There you get a different rule applied. And although there aren't any cases that really expand on that, there are certainly differences between claims involving attorneys and claims involving insurance agents. Attorneys have different duties. There are potentially privileges at stake. There are other complications that might justify applying a different rule when the claim is when it's a legal malpractice claim instead of an insurance agent malpractice claim.
I guess what I'm asking to be more
I'm sorry if I
explicit.
didn't answer.
No, I need to form a better question, is CDT said that the commercial union, the holding of commercial union applies to malpractice cases against all manner of professionals. Therefore, should we assume that commercial union applies to this claim against an insurance agent?
Again, to a point, yes. Yes, I mean, I think that there's a general proposition. Insurance agents are recognized in enough cases as professionals having the duties of professionals that you would apply generally the same rules, but perhaps with an eye toward the differences between the relationship that counsel has with a client and that an insurance agent has with a client. And in some facts, that might merit a different application of the rule.
Is there anything, can you point out anything about this case? I mean, how is there?
No,
you know,
there's
we have
nothing.
to- okay.
No, there's nothing specific because this isn't a legal malpractice case either. So
Well, so you conceding that commercial union apply, I mean, the concept of commercial union would apply as to an insurance agent? In this context, when an insurance agent is told, please, allegedly told, please get this coverage and fails to do it, you're saying that the basic principle of the knowing you're damaged and when does the damage occur under commercial union would apply here? Not necessarily the holding. I'm not saying you're admitting you're liable, but I'm just saying the whole everything we're discussing here is applicable. You're not arguing that commercial union has no bearing on this.
Oh, no, we don't think the holding is very helpful here.
And that.
Okay.
Yeah.
But yes, as a general proposition, we think that holding applies.
So let me see if I understand something that you said.
Okay.
I thought you were saying commercial union isn't very helpful because here enterprising had already been, in a sense, damaged because it had these indemnity claims, these first-party indemnity claims.
Correct.
Are you saying that's the damage? Are you arguing that that's the damage that triggers statute of limitation?
In part. I mean, that could do it, but there are several things. There's the lost business that I mentioned. There's the attorney's fees that are piling up. There's the indemnity claims. And then there's the fact that they simply didn't get what they said they paid for. I mean, they said that they had, coverage that was more comprehensive than the coverage they actually have. So there are several elements, and we're relying on all of them. They all sort of come together, certainly by the time the complaint against National Union is filed, by the time National Union files its answer. It's all clear.
Are the damages, in the sense of damages as far as these claims, they're, however, not damages that were caused by one of two defendants, by National Union. They're just damages in the sense that this was Enterprising's business, and they had claims being asserted against them. So unlike the hospital analogy I drew, would you concede that those damages are not damages that would trigger a statute of limitations? Because in the hospital context, it's somebody damaged me.
Right.
Maybe they weren't negligent, but I got damaged in the hospital. In a hospital, a nurse, an orderly, surgeon, whoever did it, somebody did it. It didn't just happen spontaneously. Maybe they weren't negligent, but I've been damaged. Maybe at the hands of one of these several defendants. Here, these claims aren't damages attributable to any one of the defendants. These are just claims that the enterprising is incurring as part of its business, right?
Well, they are that, yes, but to the extent that there is nothing to cover the incoming claims,
Right.
that they are in fact damages. I mean, they were asserted as damages in the district court, and they were asserted
Sure,
as...
they become damages when someone says, once National Union says, they're not covered.
Okay,
Is that fair?
I would agree with, yes,
Okay.
yes. If the rationale behind the discovery rule, as the Supreme Court has said, is that it's unjust to deprive a plaintiff of a cause of action before the plaintiff has a fair opportunity to assert it, the discovery rule doesn't help ESI here. ESI had abundant opportunity. It knew what it needed to know, and it could have and should have sued SunWest and the Ellises when it sued National Union. Had it done that, then the court could have efficiently dealt with all of the claims, all of the related claims, and they are all related. And that, according to Arizona case law, is how courts prefer to handle things.
Or technically, they could have sued SunWest and said, assuming for some reason Enterprising didn't really want to sue SunWest, they could have sued SunWest and said, let's do a tolling agreement. We're just doing this to make sure that if we lose against National Union, that we aren't blowing our statute of limitations as to you, and we'll make a decision after we get the National Union decision. So that's a possibility that could.
That's true, yes. I'm happy to answer any other questions. Otherwise,
Thank you, Counsel.
Thank you.
Appreciate it. Mr. Flynn, rebuttal.
Thank you. Your Honor, to your point, the damage in this case is not the claims that are pouring in, the cavalcade of claims relating to this underfunded plan. The damage in this case is the decision concerning the lack of coverage. Those are
Depending on when we want to say the damage occurred, clearly the claims, I guess, are not, claims per se are not damages to accrue that start the statute of limitations running, because that's just part of your business.
Yeah, and although those monies were at risk and those unpaid claims were at issue in the coverage case, as it relates to damages for this case, it's neither here nor there. It was the decision on coverage.
Yeah.
It was completely up until that decision concerning whether there was coverage. You have an agent who is emphatically and under oath telling you that we procured coverage. And to counsel's point about the fiduciary duty component, and we made this point in the papers, but I'll try to draw it to a fine point here. The issue was that my client requested complete coverage for its operations. It didn't request fiduciary duty coverage. It requested coverage for its complete operations. Its agent believed at that time and thereafter that is what she procured. And also to answer one of the questions concerning the answer and the impact of that, and I tried to answer it in my opening comments, but probably not well. They filed their answer with the standard denial, and additional reservation of rights letters followed after that answer. If this was such a clear-cut decision, why are reservation of rights letters coming out after that answer? Why is the district court judge not ruling on the first round of motions that come in? It takes until the second round of motions, a year and a half plus later, for this issue on the fiduciary duty piece or the fiduciary coverage piece to come into play and to form the basis for the court's decision. Your Honor, I know you have a question.
Is the agent's under oath statement in the summary judgment papers?
Yes.
Let me ask, too, with respect to the first round of summary judgment in the federal case, which I have not focused nearly as much on as the second, Isn't that, though, what commercial union looked at? When summary judgment was denied, that's when the claim accrues. So should we be looking earlier than the definitive ruling later on in the second round?
Well, no, there was no decision made.
None whatsoever.
The cross motions were denied, the case went on, discovery continued, and then we
That's what happened in commercial union, though. It was a motion for summary judgment was denied that caused the limitations period to accrue.
Excuse me one second.
Sure.
Yes, Your Honor, at that point, the court determined in the commercial union case
That this federal-
that decision, which they thought was, that decision was on point. And
There's no safe harbor
there was-
for
yeah,
the
there-
law
yeah,
firm. Is that fair?
They had no shield left. It's
Whereas here,
clear
the
cut.
denial of summary judgment left everything still open. Is that what your point is?
Yes, but in this case, everything was up in the air. Claims were being paid, and it was only until that point in time. And the decision, we're completely peaking here when we listen to counsel's arguments, because the decision could have gone any one of umpteen different directions. It could have denied some portion of the claims under the policy. There were up to 13 different potential exclusions that were identified in the reservation of rights. It just so happens we're here now with the benefit of hindsight, knowing what the ultimate unfortunate decision was of the district court. But that was the trigger.
Counsel, thank you.
Thank you.
You've given us much to think about, both in your briefs and in oral argument today, and we appreciate that. We will take the matter under advisement. We'll issue a written ruling in due course. We'll take a recess while we set the courtroom up for our next oral argument.
Thank you.
Thank you again.